Okay, hello everyone. Thank you so much for joining us for this session of the On the Mark Financial Forum and podcast. Today's session is going to be about managing finances during a divorce. We're going to spend some time specifically talking about some best practices and worst practices of dealing with the marital residence and how to navigate that process. So I'd like to welcome to the screen to show yourselves and unmute. We have two guests today, two esteemed guests joining us today. We have Richard Sperling, who is a family law attorney and mediator, and we have from Sperling and Associates, and we have Berkeley Harrison, who is the chief portfolio manager and compliance officer at Sterling Financial Group. So gentlemen, we'd love to, Richard, if you could unmute yourself and present yourself to the group. We would love to get started here.
Good morning, Mark.
Good morning. Thank you so much for joining us.
Morning, Mark.
So gentlemen, if you don't mind, just to start off, if you could introduce yourselves. Berkeley, why don't we start with you and then Richard afterwards.
Sure, happy to. Berkeley Harrison, I'm a wealth advisor at Sterling Financial Group in Pasadena. We're a registered investment advisory firm focused on helping private clients. As we have a number of people with different expertise in our firm, everything from an advisor who went to law school, a couple of folks who have MBAs, a few people with a financial planning background and certification, and myself with an investment background and credential. We bring a lot of breadth and depth to private client relationships, and we can help them with a lot of problems. Not saying that we can necessarily do everything. By no means can we draft legal documents, but because we have someone, for example, who went to law school, they can spot issues in contracts, or they can hear issues in conversations and know who might be the right attorney and which issues and what sort of fact set to bring to a future conversation, so someone like Richard could be more efficiently engaged.
Yeah, and Berkeley, one of the reasons I asked you to join specifically is because I know you and your firm specifically focus on people that are going through some sort of financial transition or a life transition. So maybe you could talk a little bit about that as well.
Sure. It's really common that people who are brought on as new clients for us are going through a little bit of a tumultuous time. We call it bringing order in times of chaos. Someone who recently lost a spouse or has gone through a divorce, and the surviving spouse is often the person who wasn't making the financial or investment decisions in the past. And they feel a little bit lost and out of control, and they need us to help provide a roadmap. We'll call it an action plan of things that are important in the first 3 to 6 months, and then make sure that the clients are aware of other things that need to be attended to in the next, call it 6 to 18 months, but to not worry about them because they're not time sensitive or critical, and we can wait on taking care of those down the road. Nobody really wants to have 4 to 6 hour meetings once or twice a month to grind through these issues, but they do need to get through a number of the issues in a timely fashion. So bringing all of our horsepower to bear in a smart manner, not trying to overwhelm the clients, is really important to get them off on the right foot.
Absolutely. Great. Well, thank you so much, Berkeley. And Richard, if you could introduce yourself as well, that would be great.
Hi, I have a family law practice and I work mostly in Ventura and LA County. But a lot of people know me as a person involved in real estate and real estate investments, because for many years I was a real estate attorney and corporate counsel for Coldwell Banker and Prudential and many of the brokerages around. And we operated a 1031 exchange company. And I teach business law and real estate at CSUN and family law at a law school in Ventura. And a lot of my practice, as Berkeley said, deals in transitions, people getting into relationships and out of relationships. And I made the transition from real estate law into family law years ago, and many of my clients are real estate professionals and real estate investors and people who are buying and selling property. So that's kind of a niche of my family law practice. We do a lot of premarital agreements and postmarital agreements as well as divorce work.
Yeah, and I would imagine, Richard, that the best practice is to have the premarital agreement in place to avoid some of these issues that we're going to probably talk through today. But I wish more
Certainly,
people planned ahead
people
for
ask
real
me,
estate purchases as well.
very true. People ask me, geez, this divorce process is so difficult, it's so expensive. Isn't there anything like divorce insurance? And I say, yes, there's divorce insurance. It's called a prenup. Sure.
Right. Exactly. Preparation in advance will often save you a lot of pain and money.
Right.
For sure. For sure. So, okay, so let's talk really quickly. Berkeley, we'll turn it to you first. So when a client first comes to you who is maybe in the beginning process of a potential divorce or a pending divorce, what does that conversation look like to you? Like, how do you navigate that process with a client?
A lot of times since we're focused primarily on the financial aspects, but we also like to bring in other professionals like Richard at some point. The first thing we do is try and just assess the situation overall, get a full tally of where are the assets, how are they titled, are there any debts on them, where are the income sources, what are the ongoing expenses today, who are all the parties involved, how old are the kids, where does everyone stand financially? And then from an emotional standpoint, a lot of times it's important to figure out how they feel about the situation right now, but also what are their big concerns going forward. Some people are really emotionally attached to a house. Say the homemaker, if there is a stay-at-home mom example, a lot of times emotionally they've invested 20 or 30 years if they're later on in life making that a home. And oftentimes they're so attached to it, they don't want to give it up, even if it's nonsensical from a financial standpoint. So sometimes just getting a sense of everything that is out there and beginning a conversation that's focused on making rational, long-term focused financial decisions is a really good starting point.
Yeah. And the emotional side is not to be underestimated, I'm sure. We actually did another session of this podcast called The Emotional Side of Money, and it was pretty enlightening to see all the different perspectives that people come from, and I won't call it baggage, but the thought processes that they come with based on money experiences in childhood and all that. So I can imagine it's a tangled web that you have to uncover. And Richard, from your perspective, what does that look like for you when a new client comes your way?
Well, ideally, the new clients coming to me before they get married and before they're buying the house,
Right.
because so
How
often
often does that actually happen, though?
luckily it does happen because of our premarital agreement practice. And when we do that, we talk about what's going on with the house. The house is usually the most valuable asset in people's lives. So we talk about the house and, well, if you're buying a house, how do you want to take title to it? You want to, with right of survivorship, where if you take title, you're buying with somebody else and you pass away, they inherit 100% of the house. Do you want to take title as a married couple? We talk a little bit about that. It's good for me to have the two of you as resources, because so often I see in a situation in a divorce where somebody says, well, I really want the house. And we say, well, can you afford the house? Can you afford to make the payments and pay the taxes and the upkeep? What's your financial situation? And that's when we can bring Berkeley in to analyze their financial situation. Or sometimes, for instance, we have a husband who says, well, I'm going to let my wife have the house. I'll just go out and buy another house. And it's important at that point to mark it for him to talk to you, for instance, to see, well, can he qualify to buy another house, particularly if he's on the loan to the house that we're dividing in a divorce. So it's great to meet people before they get married, but you're right. Very often somebody's coming in and they're saying their marriage isn't working out, and now we're going to have to divide the assets in a divorce, and without a premarital agreement, we're stuck with what we can do.
Right. And what does that interaction look like? Like if you have a client who's coming to you, what is the engagement with other professionals? Like what usually initiates that? How does that look?
You know, the classic case when in law school that we teach, it was a malpractice case where a lawyer allowed his client to take the condo, and she gave her half of the equity of the condo to the husband. She ended up with the condo. She was very happy, but not only could she not afford to pay the payments on the condo, but when she went to sell the condominium, she got stuck with all of the capital gains taxes, and her lawyer never warned her that except for some exemptions, you may have a capital gains consequence when you try and sell the real property. So we're very careful to bring in Berkeley and his group, or you, Mark, and look carefully at what our options are and what the tax ramifications are before we negotiate a settlement.
Yeah. And Berkeley, turning to you, what does that interaction look like with other professionals on your side?
Well, it's a great question because, like I said, we do have a number of different expertise within our firm, but many times it ends up opening other cans of worms, so to speak, with regard to bringing up other issues and resulting in lots of referrals to local professionals. A lot of communication and coordination is important with these other professionals who are often in the area. This firm's always been in Pasadena, and we tend to refer to people who are close to home that we might meet through a local networking group, or someone's playing a round of golf locally, or they meet at a dinner. And so many times our clients are drawn to us because they want that local customized delivery, but they also want access to them. They don't want it to be an inconvenience for either person to talk with them. And as a nice benefit, one of the things that sets our particular shop apart, we've heard from others, is that it's really easy because we tend to refer to people within our community to actually go to the meeting. And if it's something like a legal matter, if we were to tee up Richard with a trust and estate type issue, we might do some fact searching, some discovery, and lay out a fact set for him and say, hey, here are our initial thoughts as to where it might go. And that saves Richard time, but it also saves potentially the client some money if we've asked smart questions ahead of time and shepherding through the process. If Richard, for example, in a meeting between the attorney, the advisor, and the client, were to say, "Ooh, I'd really love to see some extra information, like maybe a financial plan that goes out 20 or 30 years to see if this person could last to retirement realistically," that may have a bearing upon the legal agreements they draw up. And if we're in the room and the client says, "Oh yeah, sure, they can see my financial plan," and how we'll give it to in a follow-up. And that's super easy. It's a lot of things are complicated if you have a bunch of follow-up items that result from someone not being in the room. And we find that keeping people on task and coordinating gets a lot easier if you take the time to set up a thoughtful agenda, email it to clients ahead of time and say, hey, here are the 2 or 3 things we're going to talk about today. And you push it across the table before the meeting starts. And it helps everyone's budget time that, hey, we still have to talk about these 2 other things. And then someone takes notes, including follow-up items. And many times there's homework. Mark may have to do something on a follow-up basis about a financing, arrangement to see if it's even possible. Richard may need to start drafting some legal document. We're in the room and we're going to work on, another wrinkle in the financial plan. If, say, Mark's able to figure out a creative financing solution, and the client may need to provide more information to the 3 of us just to confirm that something was retitled the way they said they thought it was 15 years ago. Many times clients are surprised that assets aren't titled the way they thought they were because someone told them they would take care of it and they never double checked.
Right. Yeah,
That's
that's
such a good point. And saving attorney time is so important to the clients. And oftentimes we sit down with people And we say, well, do you have a copy of your financial statement or your pension? No, I don't. Well, could we call your financial advisor? You know, I never can get my financial advisor on the phone. You know, it's so
Must not be
frustrating.
Berkeley.
So, you know, Berkeley, of course, is readily available, and that's so important when we sit down and go through these things. In a divorce, uh, a major step in the divorce is filling out some financial forms and disclosing our assets and debts and the details about them under penalty of perjury. So for a client to have a financial advisor that they're working closely with really makes that project more efficient.
Right. And I know this question is probably more geared toward Berkeley than to you, Richard, because I'm assuming you can't represent both sides. But Berkeley, what would happen? I'm just curious for my own knowledge, because we have clients going through, obviously, divorces, unfortunately, more common than any of us would like. But what happens if you're already working with an existing client and they're getting divorced, but can you still technically represent both of them post-divorce, or do you have to pick sides, or how does that work from a financial advisory perspective?
That's a great question. Well, on one hand, we are beholden to the fiduciary standard to do the best thing for your client at all times, not just at the moment of a transaction. We can represent both sides. It's difficult for one individual to do so. Fortunately, our shop is large enough. We have 7 people in total, 4 advisors. So it's not too difficult to assign a husband and a wife, if they're going through a divorce, to different advisors. And oftentimes, both sides will ask once things have been finalized. Often in the beginning, there has to be a lot of information sharing about what the other one had told the other one, just to get through the process. We encourage everyone to throw all the cards down the table. Otherwise, later on, you just end up renegotiating everything and unfortunately re-engaging the attorneys. No offense, Richard, but we'd love to do it once, not keep reopening it every couple of years because someone finds out more information. But we have no problems with clients if they choose to be separate. Our shop's gone through this a few times in the last 30 years, where someone says, okay, now that things are finalized and we have our separate households, please don't share information with the other household about my situation, for better, for worse. They don't need to know. Like, okay, not a problem. We can also assign the day-to-day person they'll often call our client relationship manager, who handles things like wires, opening up accounts, etc. Our client relationship manager. We can assign a different person to both households as well. So it is doable. It's a little bit tricky, but legally totally possible, and functionally as well. Some people decide they want nothing to do with them. They want to distance themselves as much as possible. They leave town. They get a different advisor. Fine, no offense, but it is something we can handle.
Okay, that's great. And this is something that we often see when we're trying to help clients navigate a divorce situation and what to do with the resident. Some of the things that each of you have mentioned as far as like, well, can they afford the home even if they get it? Can they afford to stay there, or can they afford to buy something else? But what we often find is when they're negotiating around the marital residence, that quote unquote, I'm putting in quotes here, amicable divorces tend to come with them making some of their own non-binding agreements that don't make a lot of sense. So I'm kind of curious to hear from both of you what, Richard, we'll start with you first, what your experience is with if somebody comes to you and say, well, we're amicable. Does that usually create more problems than if they're wanting to keep everything, through the attorneys?
Well, amicable is a great word. You know, it's very hard to go through the end of a marriage and remain amicable. The emotions are running high, and we're dealing with assets. Some of the assets are very valuable. We're taking a marital community and dividing it in half, and so there's severe consequences to what we're doing. Luckily, about 95% of divorces don't go to court, and so when we say they're non-adversarial or amicable, what we mean is we're able to resolve them without going to court and having a hearing or a trial. There are some strategies we use. For instance, And when people initially separate, emotions are running highest. And when somebody says, okay, I'm ready to go to court, let's file a motion, a wise attorney might say, well, I'll tell you what, let's wait a couple days. Let me make a phone call to the other attorney and let's see what we can work out. And if we use strategies like that, sometimes we can avoid going to court. And when we go to court, usually the process goes off the rail. I do want to mention a couple of alternatives to a standard or customary divorce process. One is a mediated process where the spouses will go to a mediator, and in a series of sessions, they'll sit at a table, maybe in person or maybe by Zoom, and talk about their positions and also the reasons for their positions. And a lot of times at the mediation, we'll have Mark, a lender, we'll have you come in and counsel what people can afford and qualify for. And Berkeley can come in and help not only exchange information, but also tell us what we can expect from a financial point of view. So a lot of cases where I might be mediating, where I'm neutral, each party might be consulting with their own lawyer, but the work is done with both parties. Another optional approach is what we call collaborative law, where both parties come to a table with their own lawyers, but the lawyers each promise in writing that if the case doesn't settle and if it goes to court, they'll withdraw from the case. And in a collaborative law approach, we're sitting at a table with Mark and Berkeley and both lawyers, and we can resolve a lot of cases like that. So amicable luckily applies to most divorces, even though it can be a difficult process.
Yeah, I'm sure it's not always what it looks like in the movies, which is usually the ones that go to court, I would imagine.
Right.
But yeah, we just see often that people come with these, oh, they've already made some agreement between them before they even engage attorneys, or maybe they're trying somehow to avoid engaging attorneys, which is probably a really bad idea.
Well, Mark, you bring up a
Yeah.
really important point, and that is sometimes people will call me and say, we would like to avoid a divorce. We just want to enter into a written agreement separating all the assets, dividing things up. Can we enter into a postnuptial agreement doing that? And the law is very clear that if a husband and wife or if spouses are contemplating divorce or ending their marriage, they're not allowed to enter into a postnuptial agreement. They have, in order to reach an agreement that's binding, they actually have to file a divorce action or a legal separation action, and then enter into a written agreement within that context.
Is that because of community property state rules?
Right.
Got it.
Yeah.
So that might be different potentially if we have listeners on the East Coast in New York or wherever. That I don't know the exact rules with New York specifically, but in other states, the rules could theoretically be a little bit different.
Right. And in most states and in California, if you're not contemplating divorce or if you've reconciled, you can enter into a postnuptial agreement. And one of the more famous ones is with Ron Burkle, who owns the grocery stores and is a movie producer, and he entered into a postnup with his wife and gave her $50 million. I shouldn't say gave her, but she took $50 million in that postnuptial agreement, and the agreement was ruled enforceable.
Yeah, interesting. Berkeley, have you come across this where they've come to you after they've already sort of talked amongst themselves and made certain agreements that you might not necessarily agree with?
Hey, we haven't really, but I want to make sure that if it's a quote unquote amicable arrangement that may predate any sort of discussions with attorneys and or a mediator, that they don't get themselves into some kind of a somewhat binding agreement or understanding that just doesn't make sense on paper. We sort of circle back to what we touched on before, like make sure that as part of this arrangement that it makes sense for both parties. We touched on things like, staying in a home that you can't afford, being smart about things like potential capital gains. In the example, you keep the house amongst the two of you, the other spouse keeps the investments, or be smart about, on paper, there's a trust investment account that has $1 million in it, and there's an IRA that also has investments that has $1 million in it. But on a go forward basis, those are different in terms of taxability in the future. Unless it's a Roth IRA and you've already paid the taxes, the income, the withdrawals coming from the IRA, that's taxable, whereas the trust isn't. You may be paying taxes along the way on interest or realized capital gains, but those are different assets that may initially, Richard, I'll turn to you and say, in your experience, do courts look at those assets the same way unless someone brings it to their attention?
Well, Berkeley, great question. That's where your expertise really comes in. I've got a mediation going right now where the husband is working, the wife is not. He's struggling to pay spousal support to her, and she's inherited $10 million. So the law says that even though she's not working, the income off investing that $10 million should be imputed to her for support calculations. But who knows what kind of income, what's a reasonable income should she be earning? So in the mediation, I turned to her and said, what kind of money do you earn every month or every year from that $10 million? And she said, well, I don't earn anything off it right now. I just it's in my checking account. And well,
Oh,
that
no.
so at that point we say, well, oh, I've got a great financial advisor. I need to make a referral. We need to talk to Berkeley right away. But the other question is what the husband is going to ask, or what a judge would want to know is, what kind of income can we expect if we invest that money prudently? And that becomes a very important issue in the divorce.
Yeah, and probably an impossible question to really answer, I would imagine, because it depends on the investment mix and, how long of a period of time you're looking at. I imagine that's you're going to be put under the microscope with whatever answer you give.
A tough question.
Yeah, it is. It is for sure. So one thing I want to turn this a little bit more focused onto the marital residence issues that we often see on the mortgage side. So we've had a number of clients over the years who have come to us and they're trying to qualify for a new purchase, and they're saying, well, we have some credit issues because someone told us that if we continue paying the mortgage during the divorce, that then it's going to look to the courts like it's our responsibility. And so somebody told us, a friend told us, who knows who it was, probably was an attorney, stop paying the mortgage. Because then it looks like it's your expense. Have you guys ever run across that, or any clients ever ask you that question, and how do you navigate that answer? I know what the answer is, to protect your credit, obviously, but I'm sure it's more complicated than that for you. So Richard, let me start with you on that one.
Well, I agree with you, Mark. I know Berkeley's going to say the same thing. We want to keep our payments current, and in fact, when we file for divorce, the court, at least in California, issues what we call standard or automatic restraining orders, which orders the spouses to continue the status quo and keep the payments current on all of their debts and expenses. So it'd be a violation of that restraining order to stop paying. We think it's important to keep everything current, and that's why when people separate or when people file, one of the first things they should talk about is who's going to use which asset, and who's going to pay which debt or expense, so we can keep things current. We think it's important to keep them current.
Yeah, for sure. Berkeley, do you have anything to add to that?
I would echo what both of you were saying. It's important to preserve your credit standing and to keep making your payments. And at the same time, I think it's important to highlight to all parties involved exactly not just the titling, but who signed on a particular property, the debt associated with it. If on the mortgage loan they're co-signers, as they often are, it doesn't really matter in the eyes of the lenders, in the eyes of credit reports. If there were to be a future default or just delayed payments, it goes as a knock against both people's credit reports. And that will just make life more difficult, as I'm sure you can attest to, Mark, for either party qualifying for credit down the road. It's definitely something we would make sure that is highlighted to everyone so that in the discussions, even though it may be a difficult emotional hurdle to get over, deciding to separate from a co-owned property may be a nice clean way to, clean the slate, so to speak, and start over, so that you don't have an attachment of someone as a potentially liable party on a credit arrangement like a mortgage loan going forward, even if they didn't get the house in the arrangement. It'd be an awkward thing going forward at best.
Yeah, and I'm glad you touched on this because this is one of the main things I wanted to talk about today is, if you have, and the most common way this comes up for us right now is that people own the marital residence together. They both signed on the loan. Both spouses are on it equally, from a banking perspective. One of them takes over the property or keeps the property after the divorce, but they don't want to replace the mortgage because they have a 3% rate on it. And they can't get that now, right? And maybe never again, who knows?
That
But
wasn't,
that's a big issue that we're seeing because they maybe can't afford the property unless they have that 3% mortgage. But if they keep it, in the eyes of a lender, when you sign on that loan, you are equally responsible to make sure that that loan gets paid on time and that the loan eventually gets paid off. And if let's say it's the non-working spouse that takes over the marital residence, but they can't afford it long term and they miss a payment or default on the loan, that's going to still impact the other spouse's credit profile. And that's something I think people often don't understand. And they come to us and they have this issue already and they say, well, I'm not responsible for that payment. Maybe not according to your divorce decree, but certainly as far as your agreement with the lender could care less about what agreements you've made between the two of you. They only care about the agreement that each of you collectively made with the lender. So I'd like to hear what you guys have to think about, what your experience has been with that issue.
that wasn't always the law. Years ago, when people divorced, if we had a divorce judgment that said, okay, the husband's moved out, and he's conveying his interest in the house to the wife, and the wife's going to take over the mortgage. Years ago, lenders would not consider that the husband was responsible on the loan anymore. But these days, Mark, you can tell me if I'm wrong, but these days it seems like the lenders are saying, no, I can't qualify you to buy a new house because you're still a borrower on that old mortgage. Is that what you're seeing also?
Well, that issue we can usually dance around if a client can show proof of payments from the other party exclusively from a non-joint account. So one that, let's say the spouse, the non-working spouse is keeping the home and she or he can prove that the departing residence has been paid by the other person exclusively for a full 12 months, then in many cases, not all, but in many cases, we can ignore that payment. But what we can't ignore is late payments or that affect the credit report. We can provide that as an explanation, but many programs are and lending outlets are very concerned about your past mortgage payment history for obvious reasons. They're trying to predict the future of whether you'll pay that mortgage. So we can oftentimes ignore the debt when we're trying to qualify somebody for a new mortgage, but we can't ignore the fact that the other person may have not held up their side of the agreement with making the payments on time. And where this often comes up is the non-working spouse who falls into some sort of financial difficulty, maybe for lack of planning or lack of resources, or just not being used to being the one who makes the payments physically, because sometimes it's not a financial issue. It's just they're not in that mind frame of being the person who pays the bills, and sometimes they miss it, and it can absolutely impact the other person, even though they've made an agreement between the two of them.
Interesting. And the other issue I run into a lot is one of the spouses knows that he or she wants to buy a replacement property. They're going to move out of the house and buy their own home. and they're about to apply for the loan, and they decide to file for divorce. And then the spouse applies for their loan, and the lender says, I'm sorry, we can't loan until you're divorced. And we say, wait a minute, we've got a temporary order saying that he can buy his own place, that the wife has no interest. She'll sign a quitclaim deed. She's taking over the existing loan. She'll make the payments. And usually the new lender will say, no, until this divorce is final, we're not going to loan, which is a shock. So we tell people, consider not filing for divorce yet. And if one of you wants to go out and apply for a loan and buy a residence for yourself, consider trying to do that while you're still married, because once you file for divorce, you may not be able to qualify until the divorce is final.
Right. And you also, you run into the issue that I mentioned, is that you don't have that 12-month history of the other person making the payments.
Right.
So, in some cases where there is a longer term negotiation process going on with the divorce, we might be able to tell the clients, okay, maybe start, talk to your attorney or advisor first, but maybe start that process of having one person make the payments out of a non-joint account for a period of time, so that we can show the history of that and make a case to ignore that expense. Because otherwise, you're basically, what a lender is going to do is make you qualify carrying both properties as though you were going to keep both of them forever. It's like this is what lending has gone to since 2008. They assume worst case scenario on everything from an underwriting perspective. And if you still qualify, great. And there are some workarounds, there's creative financing products, but this is an issue that comes up often, that in my experience, we usually get brought in too late. I'm sure it's same for both of you. If we were brought in early, we could advise on those things, but often we're not consulted during those moments of negotiation or initial conversations during one of those amicable divorces, which is probably a spectrum of amicability, if that's a word. But it's I wish we were brought in earlier, as I'm sure both of you do. But that's the main issue that we're seeing often, is people can't afford the home if they don't keep that 3% rate. But if they keep it, that means that they're both technically obligated to continue making those payments, or to make sure that they're being made. And sometimes they're not. And that can affect both parties even after their divorce, many, many years later. The other thing we've seen, I'd like to get your perspective on this as well, is in one of those more highly amicable divorce situations, or maybe they're trying to avoid the cost of legal representation, is that they offer to co-sign for each other, which is even worse. Because now not only are you tied to one property, now you're tying yourself to another property that the other person is responsible to make payments on. And who knows, you're predicting potentially 30 years into the future that person will be able to continue making their payments on time. But have you guys come across any situations where, let's say, the working spouse says, oh, well, part of the agreement is that I'll co-sign on a loan for you to buy another home?
We haven't come across that one. I mean, as a parent who recently launched their kids into the real world, after their first apartment, my wife and I are reluctant to co-sign anything with our kids, wanting them to fully absorb what it's like to bear the burden, the responsibility of just making a payment on an apartment, much less, a car payment or a future condo payment, if that comes down the road. I'd have a hard time seeing any advantages to co-signing on both properties on a go-forward basis, just because of the legal and financial entanglements, and so many things could go wrong. It may look okay on paper at the very beginning to say, oh, this is the only way we can both qualify for financing for both properties, but it just creates so many extra headaches. It would be lovely if you could march in a situation where there were enough resources to just go buy the other asset in cash. You didn't have to worry about any financing, or the timing of the divorce isn't finalized yet. But even then, sometimes you have to weigh the pluses and minuses of different options. If you try and avoid the financing, some clients just throw up their hand and say, well, I want that next property now. And sometimes they play those cards even when there's not a divorce scenario. They just want to go buy their mountain house now because they were just vacationing there and they want to go get it tomorrow and not spend 90 days lining up financing. And they say, well, just sell some investments. And you're like, oh, there are capital gains in all those investments. You're
Right.
gonna have to pay taxes on those. Why? I mean, I'll put the money back. And you're like,
Right.
time out.
Yeah, the house
It's
just
funny
cost
what
you
problems
25% more.
clients get themselves into by not thinking things through. And
Yeah,
that's oftentimes why we're there to help them explore different options.
yeah. Richard, how about you?
Well, that's really a good point, Berkeley. We may have 20 or 30 issues to talk about in a divorce. And many of them have extreme consequences, sometimes tax consequences, sometimes Berkeley can point out financial consequences and why one investment's risky and the other investment is prudent. And we may have one issue come up where somebody says, I want to go out and buy a condo and I want you to co-sign on the condo for me. And that might be issue number 3. But issue number 1 might be who's going to get custody of Fido. And issue number 7 might be who's going to get the Ferrari. So for some spouses, it's okay to enter into agreements regarding 1 or 2 or 3 issues, not knowing what the other spouse is going to say or what position he or she's going to take regarding issues 19 and 20. But for others, they may co-sign on a loan and then find out that they're in a custody dispute and that their spouse is being very unreasonable. So it's important for divorce counsel to point that out to their client and say, hey, before you enter into an agreement or before you co-sign on this loan, let's get a feel for what this entire case is about. And let's see if we can enter into some kind of agreement that's binding. And as I touched on before, when a divorce is filed or a written agreement, unless it takes a certain form, a written agreement and especially a verbal agreement between spouses is not binding. So it's a risky area.
Yeah. And one other thing we see often is that sometimes people attach some of the emotional value to the home. So when they're separating assets, they give more value to keeping the home because they don't want to move. Their kids have grown up there. They want to keep their kids there. They want to keep them in school, all these things. And so sometimes we've seen situations where during the divorce, one of the spouses keeps the home and the other gets the investments. And then you run into this situation where, okay, well, how is the person who's keeping the home going to support themselves long term? And that can often complicate things as well. And that's why what I was saying earlier about how people kind of come up with these ideas first before they go seek professional help and they start talking about them maybe with the other spouse that they're divorcing from or planning a divorce with, and they get these ideas in their head and then they attach emotional value to those assets without having an outside party kind of reset their expectations and say, well, this home only has $200,000 of equity in it. It's not worth the same as the $1 million investment account, even though it's worth $1 million. It's got 800,000 of debt on it, So it's just interesting how sometimes people place the emotional value on certain assets that are important to them for one reason or another. But one of the things I think also that people need to navigate is when they're navigating the settlement agreement and who gets what and how does this work, who pays for what, is also looking at when we get engaged in these discussions is we're looking at, okay, what are your goals for the future? Do you want to buy another home? Do you want to buy a house in the mountains, as you mentioned, Berkeley? Like, what are your goals? And is the legal agreement that you're putting in place going to facilitate that? So if you're just getting a lump sum of assets, but you're not getting, let's say, alimony or child support or whatever it may be, from a lending perspective, alimony and child support are considered regular income, much easier to qualify for conventional financing than if you're just getting a lump sum of assets and you don't have traditional income that you can use on a loan application. So if your goal is to purchase your own home, but you're negotiating something where you're not getting what a lender considers to be income producing assets, even though investments are, but oftentimes that income may get reinvested and not actually show up on a tax return, you're not setting yourself up to be able to achieve your goals. So one of the big takeaways, I think we've hit on this in many different ways, is that you have to engage your whole community of advisors when you're going through this process, because there are so many nuances to where, for example, Berkeley, you may be looking at it from the perspective of dividing up the assets and trying to make it as even and amicable as possible. Richard, you're dealing with the legal side. Oftentimes, people like me in the lending world are not consulted on these things, and people set themselves up to either not be able to achieve their goals or to have to take certain creative loan products that we can offer that might have meaningfully higher interest rates, to where it becomes less affordable or less desirable to do the things that you think you want to do. So I think one of the big takeaways from today's session is you have to engage your whole community of advisors. For me, I just love putting people in the right position. I don't care if it turns into a transaction later or not. I just want to be a resource for people, and I'm sure the two of you feel the same way. But in kind of wrapping up, if there's one thing you either, for each of you, you say, I wish everyone did this or didn't do this. What's that one takeaway that people can have from today's call that each of you would say? So Berkeley, we'll start with you first.
Well, I think more than anything else, if you're starting these discussions and you say to your an advisor, whether it's someone who's originally the real estate person, and they could turn to you first, Mark, as an advisor to them and say, gee, we're thinking about a divorce. I think the important thing is that they decide to pull in a number of different people onto their team, and both of the two parties need to throw their cards down early and just say, hey, here's what we've got. Here's the detailed inventory of assets and liabilities and income, and here are the concerns excuse me, from both parties, and to try and get to a realistic place of what's achievable. And they may need to the clients may need to leverage someone like ourselves with a financial plan. They may need to leverage the talents of someone like Richard to figure out what's doable legally. They may need to leverage you, Mark, to figure out what's possible from a creative financing standpoint if they need that for future engagements. A lot of clients, I think, naively go into it and think, oh, we should just do it, X and Y. Like, you take the house, I'll take everything else, without even beginning to think it through. I think the detailed inventory of everything they have and their major concerns is probably a really important starting point, and to not forget about taxes along the way.
Yes, taxes change everything for sure. Richard, what would be your one nugget for people to take away? If you had to choose one, I know there's usually like 30 things that you're negotiating, but what's the one you wish, like, oh, I wish everybody knew that or did that?
I really like what you and Berkeley are saying. Talk to your advisors and talk to them soon. So you can say, hey, Mark, can I really qualify for this condo? Berkeley, should I take this cryptocurrency instead of taking an interest in the condo? Those talking to your advisors and sooner rather than later is so important. And then I just need to say premarital agreements can be so helpful as people get into their marriage to say, here are my assets, here are my debts, and let's talk now about what our goals are, how we're going to spend our money, and what would happen, God forbid, if one of us passes away or if our marriage doesn't work out. I think my nugget is a premarital agreement.
Yeah, I think that's a good one. And if I had to chime in with one of my own, oftentimes one of us professionals, or maybe a tax professional, CPA, one of us is the entry point for that initial conversation where they reach out. Sometimes they'll reach out to me and say, can you help us figure out a buyout agreement before they've even talked to an attorney or an advisor? How can we figure out how much money I need to buy out this person? What are the implications? The capital gains tax if we sell the property, all these different things. So I like to raise the red flag and say, hey, you need to talk to other professionals, kind of along the lines with what you were saying, but not to overstep as a professional, not to overstep our individual roles, and to make sure that you've got a comprehensive team of advisors. This is something I'm very big on. We have a little post-closing gift book that we give to our past clients, specifically about creating your proper financial and advisory team, because so many people don't have that and don't even know how to do it. But I think that's the critical piece, is don't just rely on one person who may give you lots of advice, but maybe neglecting some of the implications, or just not thinking through the implications of what that looks like for different people with a different perspective, maybe an expert on taxes or financial advice or legal side or whatever it may be, but don't rely on only one person. That's my takeaway, because I've seen clients do that, and I don't want to take on that burden for them either, or overstep. But listen, gentlemen, I really appreciate you guys taking the time to share your insights. I think this is, something in the lending world that people often don't talk about and don't really understand what the implications are, and they take a lot of missteps. So we will definitely encourage our clients who are going through this type of situation to check this session out and benefit from it, and hopefully avoid some of those missteps. And I'll tell all my clients, Richard, that before they get married, when they call me to say we're getting married soon and we're buying our house, I'll make sure that they come to you for that prenuptial agreement.
I
So
look forward to working with both of you. Thanks.
yes, likewise. And so our next session is going to be August 7th. So tune in for details on that. Appreciate all of you joining us for this session of the On the Mark Financial Forum and Podcast. Thank you again, Berkeley and Richard, for your expertise and your time. And we will see all of you next time. Take care.
Thank you.